The Honorables, the presiding Chief Judge and Judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good morning, everyone. Welcome to the North Carolina Court of Appeals in the virtual world here today on WebEx. I'm Chief Judge Donna Stroud, head of the panel today, and I'd like to introduce the other members of the panel. We have Judge John Airwood and Judge April Wood with me on the panel today. And we have one case for argument this morning, which is State v. Montez Gibbs. And I believe we are ready to proceed with the argument from for the defendant from Mr. DeSimone.
Good morning. May it please the court, I'm Assistant Appellate Defender Andrew DeSimone, and I represent Mr. Gibbs. I'd like to reserve 5 minutes for rebuttal. I want to start with why the errors here mattered so much before getting into the errors themselves or State versus Garrett. At the time of Mr. Gibbs's offense, the trafficking statute only prohibited possession of opium or opiates, not opioids. The state charged Mr. Gibbs in the indictment with trafficking in opiates. The trial court understood that that meant the state had to prove Mr. Gibbs possessed opiates. So the trial court instructed the jury that it had to find Mr. Gibbs possessed opiates. So if Miss West had been prohibited from testifying that fentanyl was an opiate, the state's proof at trial would have failed. The trial court would have granted a motion to dismiss, or the jury would have acquitted Mr. Gibbs. The trial court even said so. That's why the errors were so prejudicial here. Now, I'm going to focus on the discovery issue, but I'm happy to take questions on any of the other issues at any time. The state gave notice to the defense here that Miss West would testify that the substance in the backpack was fentanyl. The state never notified the defense. Can you hear me?
Yes.
Okay, sorry, I lost all your videos. The state never notified the defense that Miss West would provide expert testimony that fentanyl was an opiate, which was the key issue at trial. The state conceded at trial it did not know what Miss West would say about that. That's a discovery violation. Yet the trial court overruled the objections and allowed the state to elicit Miss West's testimony that fentanyl was an opiate, which supplied proof of an essential element of the crime that was charged. Now, the two reasons that the trial court gave for ruling that the state did not violate its discovery obligations were just wrong. First, the trial court said that Mr. Gibbs had notice that Miss West would testify fentanyl was an opiate because the Schedule II statute in effect at the time of his offense defined fentanyl as an opiate. Well, just to begin with, that logic doesn't work. Even if the statute had defined fentanyl as an opiate, that doesn't mean the defense had notice that the state's expert would testify that fentanyl was an opiate. But even setting that aside, the statute did not say that. Effective December 1st, 2017, that statute was amended to say that fentanyl was either an opiate or opioid. It no longer defined it as an opiate. So at the time of Mr. Gibbs's offense in 2018, the statute did not provide notice that fentanyl was an opiate or that the state's expert would say that at trial.
What did the statute say at the time? You say it was changed. What did it say? What did it say prior to that?
So prior to the change, it said the following controlled substances are Schedule II, and then it said the following opiates, and then in the list of opiates was fentanyl. So basically, it's saying these opiates are Schedule II controlled substances, and in the list of the opiates, it said fentanyl. After the change, it said the following opiates or opioids are Schedule II substances, and in that list remained fentanyl. But at that point, it no longer is saying definitively that fentanyl is an opiate. Now, the second reason that the trial court gave for ruling the defense had notice was that Ms. West's CV indicated she would qualify as an expert in forensic chemistry. But that also did not tell the defense that she would testify fentanyl was an opiate. Now, our Supreme Court rejected a very similar argument in State versus Davis, where the court said there was nothing in the experts' CVs that would alert the defense that the experts would give the opinions they gave. The same is true here. Nothing in Ms. West's CV said she would testify that fentanyl was an opiate or an opioid or a lemon or a tuna or anything. Nothing at all. And again, the discovery violation mattered here. If the trial court had excluded Ms. West's testimony that fentanyl was an opiate, the trial court likely would have granted a motion to dismiss the trafficking charge, or the jury would have acquitted. So the error should result in a new trial here. Now, I do want to address the opinion in State versus Garrett. The state wants to use Garrett to say that none of the errors here were prejudicial because the trial court could have instructed the jury that fentanyl was an opiate as a matter of law, thereby relieving the state of its burden of proof on that issue. But the trial court absolutely could not have done that for several reasons. But before I get into the reasons from my supplemental brief, I need to bring to this court's attention another reason Garrett is not binding that only came about after I filed the supplemental brief yesterday afternoon. And boy, this is a dynamic case. Late yesterday afternoon, our Supreme Court issued a temporary stay in State versus Garrett based upon very recent precedent from this court, including a case I lost because of this stay issue, State versus Connor. When the Supreme Court issues a stay, the case is no longer binding precedent on other panels of the Court of Appeals. I will put the stay in Garrett and Connor in a memorandum of additional authority after the argument. But for this reason and this reason alone, Garrett is not binding on this court at all. It is stayed. But also, I'm not afraid of Garrett because whether an indictment sufficiently alleged a crime is a very different question from whether the state can prove that allegation at trial. So the Palmer case I cited in my brief is a good example of this. In Palmer, our Supreme Court held now the indictment for assault with a deadly weapon was facially valid because it alleged that the stick used was a deadly weapon. But the court said, quote, whether the state can prove the allegation is, of course, a question of evidence, which cannot be determined until trial. And the court held that because there was conflicting evidence about the stick and how it was used, the trial court could not have instructed the jury that the stick was a deadly weapon as a matter of law. The same goes here. Just because fentanyl can qualify as an opiate for purposes of an allegation in an indictment does not mean it's an opiate as a matter of law for purposes of the state's proof at trial. Whether the state can prove its allegations is a question of evidence. And here the evidence was equivocal as to whether fentanyl was an opiate, an opioid, or both. And it would have been even more equivocal if the state had complied with its discovery obligations. You know, like the defense said at trial, if the state had disclosed that its expert was going to testify that fentanyl was an opiate, the defense would have gotten its own expert to testify it was an opioid and not an opiate. The state's expert even said there were members of the scientific community who held that view. Now, Garrett also does not control because it interpreted a different statutory scheme. You know, the Garrett court said several times it was interpreting the statutes in effect at the time of the offense in 2016. At that time, like we talked about, Judge Arrowwood, Section 90-90, subsection 2, explicitly said fentanyl was an opiate. But that statute was amended before the offense date here to say that fentanyl was either an opiate or an opioid, and the definitions section of the Controlled Substances Act was also amended at the same time in 2017 to add a separate definition of the term opioid. So at the time of Mr. Gibbs's offense, the statutes did not say that fentanyl was an opiate. Garrett did not discuss the 2017 changes to the statute. So Garrett is neither binding nor persuasive as to the meaning of the term opiate in the 2017 statutory scheme under which Mr. Gibbs was convicted. Now, another reason Garrett should not, go ahead.
I have a
Yeah.
question. So the main issue you have is that the state provided West's CV and the lab report, which said that the substance was fentanyl. But your issue is that the state didn't provide the underlying basis for her opinion?
No, the issue is that, as it turned out, the key issue at trial was whether fentanyl was an opiate, because that was what the state charged. You know, like in Garrett, the indictment said you trafficked in fentanyl. It didn't say anything about opiates.
I understand that, but she testified that under the circumstances, she would define it as an opiate. And your contention is the state should have given you the information that that's what she was going to testify to?
Yeah, that it was opiate, and then why? What is the basis for that opinion? Those are the two things that weren't provided. Because, you know, like we know, if anyone is to be convicted, you have to be convicted of the crime that was charged in the indictment, and here it was that he possessed opiates. Now, going back to Garrett, Garrett should also not control because it did not discuss the rule of lenity, even though it said that the meaning of the term opiate in 2016 was ambiguous. Now, the meaning of the term opiate in the 2017 statutes was even more ambiguous because the statutes no longer definitively said that fentanyl was an opiate. So here, applying the rule of lenity means that fentanyl was not an opiate as a matter of law for purposes of the state's burden of proof at the trial. Garrett even said that fentanyl is usually considered to be a synthetic opioid, right? That's what the DEA classifies it as. That's what it normally is referred to, not an opiate. I did want to touch on my two constitutional bases as well. So retroactively applying Garrett, which addressed a different statute to hold that fentanyl was an opiate as a matter of law at the time of Mr. Gibbs's offense, would be fundamentally unfair and violate due process. You know, at the time this case was being tried, the trial court agreed that whether fentanyl was an opiate or an opioid was a question of fact for the jury. Mr. Gibbs also knew going into the trial that the state had not disclosed that its expert would testify about an essential element of the crime, that fentanyl was an opiate. And with all that in mind, Mr. Gibbs made the important decision to plead not guilty and take this case to trial. To say now that the state didn't have to prove that fentanyl was an opiate would change the playing field after the game was played to get a different result, and it would be fundamentally unfair.
What about the fact that when the state brought up the preliminary discussion with the judge, and then your client's trial counsel talked about, well, we'll just let it play out and see how it goes. Why didn't they ask for a continuance then? Why isn't the burden on them if they think they're going to change it? Testimony is going to change. Why isn't? And the state had offered a continuance previously because they had not properly or not timely done the video, if I understand it from the record. Is that correct?
That's correct, yeah.
And your client declined that. And then when they got to this argument, your client's counsel said, well, let's just wait to see. Judge said, let's wait to see what she testified to, and your client said, I think that's what you should do. Is that correct?
Right. Well, basically the question was, is it a matter of law or fact, is what they're really saying, because the state was asking for an advisory ruling. Can I prosecute this person, right, who had fentanyl for trafficking in opiates under the statute as it was at the time? The defense is saying that's a question of fact for the jury. It's going to depend on what the expert says, knowing that in the back pocket, they never disclosed that the expert was going to testify that fentanyl was an opiate. Nothing in that discussion gave any notice to the defense that the expert would actually say that. In fact, the state said the state didn't know what the expert would testify to about that crucial issue. So nothing gave him notice at that point either. So there would be no reason from the defense perspective to seek a continuance when the whole reason they probably went to trial was because they knew the state's evidence would be lacking on an essential element of the crime and they would win a motion to dismiss.
Mr. DeSimone, do you dispute whether or not West was qualified to testify that fentanyl was an opiate?
I do dispute. Yeah, I wasn't going to focus on that today, but we stand by our argument that she was not qualified, and that is a preserved issue. Now, the reliability prongs, I can see that was not preserved properly at trial, so I raised plain error as that. But the qualification was renewed at the very moment she was qualified in front of the jury. So that is preserved. You know, she was not a doctor. She said she did not know about, quote, the receptor sites that the opiates are shown to attack. She could not speak to the addiction forming or addiction sustaining liability of opiates. She could not speak to the effect of synthetic drugs. Fentanyl is a synthetic drug. She had not received training about addiction forming or addiction sustaining liability, and she had never been tendered or accepted as an expert in that area. So she was not qualified to testify fentanyl was an opiate because that opinion was not based upon scientific, technical, or other specialized knowledge. What we're not saying in this issue, I'm not saying she was completely unqualified to give any expert testimony, right? It's just that her testimony that fentanyl was an opiate exceeded her expertise that was on the record, like in Ward and Goodwin, cited in my original brief.
What's the test for determining error here?
As to the qualification,
As to when
yeah.
the court found her to be qualified, yes.
As to the qualification, that is reviewed for abuse of discretion. So it's a high standard, but that standard should be met here, given records, transcript pages 221 to 222 and 280, where all of those things came out about her lack of knowledge about the receptor sites that opiates were shown to attack. If you don't know that, then you can't say it meets the definition, because that is part of the definition. And this is certainly beyond the knowledge of laymen as to whether fentanyl is an opiate or an opioid. Now, I don't think this case will impact many other cases, if any. There's sort of a donut hole here. Remember the donut hole? We're bringing it back from the JRA, but so there's a donut hole for those like Mr. Gibbs who were convicted after the 2017 amendments, but before the trafficking statute was amended again in 2018 to add opioids to the list of prohibited substances in 9095 H4. This case falls into that 1 year period where fentanyl was either an opiate or an opioid, and opioids were not yet prohibited by the trafficking statute. So it's fairly unique. Now, I'll wrap up and save the rest of my time for rebuttal unless you all have other things you'd like to discuss with me.
Get unmuted.
Okay, I'll repeat.
All right, I'm sorry. I was muting so you wouldn't hear the jackhammer out my window. All right. Thank you, and we will proceed with Mr. Dunn for the state.
Thank you, Your Honors. May it please the court. Zachary Dunn here on behalf of the state. There are 4 issues before the court. The first 3 deal with Mr. Gibbs's opiate trafficking conviction and Ms. West's testimony, and the final one deals with one element of the resist, obstruct, and delay charge. And I'd like to begin where Mr. DeSimone did with the first issue, which is the discovery violation issue. Defendant argues that the state committed a discovery violation by failing to disclose that its witness would testify that fentanyl is an opiate. Our first contention after Garrett, and I understand Mr. DeSimone's argument about it being stayed. I frankly did not know that until today. But our first argument is that the state was not required to prove that fentanyl is an opiate. As Garrett makes clear, fentanyl is an opiate as a matter of law. But even assuming the expert testimony from Ms. West on whether fentanyl is an opiate was required, the transcript makes clear, as some of the discussion here today has already got into, that the state was unaware of the expert's opinion. At transcript page 18, this was the pretrial conference.
Well, John, if the state was unaware of her expert opinion, how could it have met the discovery statute requirements that they had to disclose what they were going to offer her as an expert in if they didn't know?
Right. Well, I think because the state was attempting to elicit a ruling from the trial court judge as a matter of law that fentanyl was an opiate. But as Your Honor was discussing with Mr. DeSimone, defense counsel, trial counsel stood up and said, no, this is an issue of fact for the jury. And that's when the state says, and quote, I have not talked to the expert about this particular issue. So it seems very clear that the state, until this transpired at the pretrial conference, the state was not aware of the expert witness's testimony on this subject. So the defendant, the state, the defendant's counsel, and the trial court all became aware of her opinion at the exact same time. So the state did not commit a discovery violation because they simply didn't know the witness's opinion on the particular subject. But even if the state was required to furnish an opinion it didn't have, there is no prejudice to Mr. Gibbs in this case by the alleged discovery violation. There are 2 cases cited in our supplemental brief, Russell from 2020 and Jeffries from 2008, which makes very clear that even assuming a discovery violation has occurred, a defendant is still required to show that he was prejudiced by the alleged discovery violation. And here, Garrett really helps us because even if it's not binding, the state would argue that much like an unpublished opinion, the force of its reasoning is very strong in that it held that as a matter of law that that fentanyl is an opiate. And so even if the trial court erred and there was a discovery violation, the defendant could not have been prejudiced by a correct recitation of a fact or something that was decided as a matter of law. I would like to touch quickly on a couple of points that were made by Mr. DeSimone. The first is the analogy to State versus Palmer.
I'm sorry, I was having trouble unmuting again there.
Oh yeah, no problem.
The construction out here. Okay, I was just wanting to ask, so you say it's, it doesn't really matter whether it's an issue of fact or issue of law, there's no prejudice, but wouldn't it matter if it is a factual issue, then that's something that the discovery would be important for the defendant to be able to evaluate the case. If it's a matter of law, then, then you don't really have to worry so much about the evidence. So if it is an opiate as a matter of law, that's one thing. But if there's going to have to be factual evidence of it, isn't that a very different situation as far as prejudice?
I think it would be a very different situation. At After Garrett, though, we believe that fentanyl is an opiate as a matter of law. So
Okay,
although
let's just assume for purposes of argument that Garrett is not there, okay? Then what is the, at that point, when they were trying the case at that time, is it a matter of law or is it a factual issue?
well, with the caveat that Garrett made it clear that the amendments to the law were clarifying rather than substantive changes. So in effect, the trafficking statute that just says opium and opiates always covered fentanyl. So that would be our primary contention. But on the discovery issue, because the state did not know what Ms. West's testimony would be on the subject, it could not have committed a discovery violation by failing to disclose it. I mean, remember going back to the pretrial conference.
Now, Mr. Dunn, as I understand what 15903A says, is it says the state shall also furnish to the defendant the expert's curriculum vitae, the expert's opinion, and the underlying basis for that opinion. And you're saying that the state didn't know, so therefore the state could not have disclosed it. But if the state didn't know it, then how can they offer an expert to testify about something when they haven't met the requirements of 15903A?
Well, because the state was not intending to elicit that testimony. Going back to that pretrial conference, the state was attempting to elicit a ruling as a matter of law that fentanyl was an opiate. And but the trial court, frankly, agreed with the defendant that there needed to be expert testimony. And then
that wasn't the state's burden to ask for a continuance, then to offer to make sure that they had had complied with the statute if they're now planning on offering an opinion that they haven't offered before.
Well, I think that certainly could have been done under the statute. The state had offered a continuance just minutes before on, like Your Honor said, on the videotape issue. But the state said, quote, "We'll see what the expert says on that subject." If the defendant wished to have a continuance at that time, certainly he could have asked for it, and we don't know what the state's position would have been.
But that doesn't relieve the state of its obligation to comply with 15903A, does it?
It certainly doesn't.
Could have asked for a continuance.
The state could have asked for a continuance, but of course the defendant could have also asked for a continuance. But
the state had the obligation to provide all of this information for any expert opinion they were planning on offering, did they not, under the statute?
I think that's right, but the key distinction there is at the time of the pretrial conference, at the time that this trial started, the state was not planning on offering that evidence, and it only became an issue when Mr. Gibbs's trial counsel said that it's a matter of fact for the jury, and that's
well, the state knew that it was an issue, did it not, or they wouldn't have had this colloquy pre-trial with the trial judge to try to get a ruling on it. They knew that there was a potential that this was not going to be as a matter of law, or they wouldn't have raised it earlier, would they?
It's really not clear from the transcript. That's certainly a possibility. It is the state, I will freely concede, was the one that brought this issue up to the trial judge. So, I simply don't know what happened before off the record or anything like that.
And the defendant obviously knew this was an issue because they had a trial brief ready to hand up about it shortly thereafter. Isn't that also what the record shows?
It does.
The parties knew it was an issue. The state by bringing it up and the defendant by having the trial brief ready. So if you knew it was an issue, why did the state not have the burden of disclosing an expert in case the judge ruled against them? I mean, they knew that there was an issue here.
I think that at least at the time that the trial started, at the time that the pretrial conference happened, the state knew that this was possibly an issue. I'm not sure when, whether it was a day before, whether it was a minute before the record starts. But like you said, if the defendant had a trial brief ready and he was attempting to defeat the state's case by this essential element argument, then not asking for a continuance really, it was on the onus of the defendant to ask for that continuance and to try and receive one.
Well, go ahead.
Doesn't 903A put a continuing burden on the state to disclose anything that they're going to offer? Does it not? Is there not a continuing burden here?
There is. Our submission is that the state didn't know of the expert's opinion until everybody found out what that opinion was in open court. So, I mean, as much as you can call that a disclosure, that the second the state knew of it, so did the defendant.
Mr. Dunn, so why would the defendant ask for a continuance when it has learned that the state is missing an essential piece of evidence that it would have to present to the jury to get past a motion to dismiss? Isn't that exactly the moment not to ask for a continuance?
I'm sure that's certainly possible, Your Honor, but the defendant also didn't ask for a continuance when the judge ruled that Ms. West was qualified to testify as to that issue. That certainly would have been an excellent time to ask for a continuance during voir dire, not just during her testimony to the jury, but there was extensive voir dire on this issue, and then there was some colloquy between the state, the defense counsel, and the trial court, and that certainly could have been a place that the defendant could have asked for a continuance.
So, Mr. Dunn, so what you're saying is the state didn't know the expert was going to testify that fentanyl was an opiate, so they were just, playing their odds at trial to determine whether or not the expert was going to testify. So, did the state at that point know that they were missing an essential element of the crime?
I don't think that the state conceived of this as an essential element of the crime. Because the state asked during that pretrial conference for an advisory ruling, essentially to rule as a matter of law that fentanyl was an opiate. And this court in Garrett held that fentanyl was an opiate. Of course,
Garrett wasn't decided then, was it?
Correct. Yeah, no, absolutely it was not. But Garrett says that that the amendments were clarifying rather than altering the substance of the statute of 90-95H4. So under that reasoning, 90-95H4 always included fentanyl as an opiate. I'd like to turn, if I could, unless there's any other questions about the discovery issue, to the expert witness testimony issue, which is really issues 2 and 3. There's been some discussion of it about the Rule 702 standard and whether Ms. West was qualified. Of course, at trial, the defendant did not challenge her qualifications to be an expert as a forensic chemist. They freely admitted that they did not have any objection to her being qualified as a forensic chemist. And, Ms. West had been at the state crime lab for more than 15 years. Had worked approximately 12,000 cases and had testified as an expert more than 100 times. And specifically, she had also attended trainings, and these were listed on her CV, which was provided to the defendant before trial, that she had attended workshops and trainings specific to fentanyl and opiate identification. And so with the abuse of discretion standard that applies here and the really high bar, quoting from State versus Morgan, it's a Supreme Court case from 2004 in our principal brief, an expert need not be experienced with the identical subject matter at issue to be a specialist, as long as the expert witness, because of his expertise, is in a better position to have an opinion on the subject than the trier of fact. So I think at least on this point, the question for the court is whether Ms. West who is an expert in forensic chemistry, was in a better position than the jury to identify whether fentanyl was an opiate. And simply our submission is that she was. It meets that high bar, and the defendant, sort of in reverse, cannot meet his high bar to show that the expert witness testimony was erroneously admitted. Sorry for jumping around a little bit, but I did want to hit on State versus Palmer, which Mr. DeSimone talked about in his argument to your honors this morning. Palmer, as Mr. DeSimone parts out, really says that sometimes whether something is a deadly weapon is a question of fact. In that case, the alleged deadly weapon was a stick, and although the indictment alleged that the stick was used as a deadly weapon, the evidence at trial ultimately did not pan out to show that it was used as a deadly weapon. But in some cases, and I would refer to the court to a 1994 case from our Supreme Court, which is State versus Bell, whether a particular item is a deadly weapon is established as a matter of law. For instance, a firearm. And here, tracing the analogy to its conclusion, we would say because of Garrett, and I know, of course, that Garrett wasn't decided at the time, but we think it still should apply, that in this analogy, that fentanyl in this would be a gun rather than a stick, something that the trial court could have just said as a matter of law is an opiate. And I want to think of the reverse. If the trial court had granted,
Well, but at the time of this trial, the statute defined it as either an opiate or an opioid, right?
that's true. So the exact language of 90-95 had not changed, but that is correct. There was an amendment between Garrett and this case to 90-90, which is another part of the Controlled Substances Act, which changed the definition or included opiates and opioids with the list that included fentanyl. But with Garrett's holding respectfully that these amendments were clarifying rather than substantive alterations to the statute, this we would argue is simply
Well,
one
you
of
do
the-
concede that now that the Supreme Court's issued a stay that Garrett's not binding, don't you?
That's correct. Yeah, it's not binding. We now cite it for its precedent or its persuasive authority. We think the court got it right in Garrett, and think that its reasoning should apply here. Unless there are any further questions on any of the issues, I'll just take a minute to conclude.
I have a question for you, Mr. Dunn. So Ms. West testified that opioids can be opiates, but all opiates aren't opioids, and the classification has gotten very muddy over time. And the statute at the time had to define fentanyl as an opioid or an opiate. So what do you contend? She said she would classify under the circumstances as an opiate. So what do you contend are the circumstances under which she should have classified it as an opiate? And what was the basis for that classification?
Well, I think I would echo what the court said in Garrett, that opiates is generally used as an umbrella term that it really includes opioids as well. Anything that acts on the brain similar to the way that opiates do, opium does. And so, just from that force of logic, we would say that Ms. West certainly was qualified under her experience and training to testify that fentanyl qualified as an opiate.
And do you concede, though, that she testified she couldn't give any testimony as to how fentanyl affected the brain receptors or anything else because she wasn't a doctor?
No, she certainly said that. But again, going back to Garrett, and I know took a little bit of the wind out of my sails when I learned that Garrett had been stayed by the Supreme Court. But this court freely said that that fentanyl acts on the brain receptors, that it's a highly addictive drug, that it acts just like opium does, and so it qualifies as an opiate. So of course, it's not binding authority, but we think that the court got it right in Garrett, and that would apply here as well.
Mr. Dodd, her talking about under the circumstances, she would classify it as an opiate. Again, what are the circumstances? Is it just the circumstances of the case? Or is there some expertise? Is there something about her expertise that would make her say, under the circumstances, she's qualifying it that way?
You're talking about specifically about her testimony that she said under the circumstances, right? Yeah, it's not really clear. I'll freely concede from the testimony how she specifically, or what she specifically meant by the term under the circumstances. So we would need to turn simply to the standard of review that applies here, that abuse of discretion standard, whether she was in a better position than the trier of fact to determine this fact, which is whether fentanyl is an opiate. So unfortunately, I don't have a more satisfying answer on that specific point, Your Honor. Unless there are any further questions, in conclusion, the state was not required to offer expert witness testimony that fentanyl is an opiate, and defendant was not prejudiced by the alleged discovery violation or Ms. West's correct testimony that fentanyl is an opiate. In the alternative, and for the reasons discussed in our principal brief, no discovery violation occurred, and Ms. West was qualified to offer the testimony that she gave. So the state would urge the court to find no error and affirm. Thank you.
Thank you. And not rebuttal?
Just a brief rebuttal. The state cannot remain willfully ignorant of evidence satisfying an essential element of the crime to get around its discovery obligations. The state drafted the indictment here, right? The state is the control of the indictment to allege opiates. The law is clear that if you're going to be convicted, it has to be upon the allegations in the indictment. So that was the issue at trial. I don't have much else. I'm happy to answer any questions, but we would just respectfully ask that this court reverse the conviction for trafficking and remand for a new trial, and just outright reverse the conviction for the resisting offense. Thank you very much.
Any other questions from the panel?
I don't have any, thank you.
All right. Well, we appreciate your arguments this morning, and this session of court is concluded.
Thank you.
This session of the North Carolina Court of Appeals is adjourned.
Thank you, Your Honor.
Thanks, Judge.
All right. Thanks.